Good evening, friends, and welcome. Thank you for joining us for the first Rupe debate of 2025. My name is Brady Marzin, and I currently serve as president of the Georgetown Law Federalist Society. On behalf of the DC Young Lawyers Chapter and the American, Catholic, Georgetown, and George Washington student chapters of the Federalist Society, we are honored to have you with us tonight. We are deeply grateful to the Federalist Society and the Arthur N. Rupe Foundation for making this amazing discussion a reality. Their dedication to civil and reasoned public debate is admirable and much needed in modern American society. Our resolution for the evening is, are independent agencies constitutional? With his inauguration on Monday, President Donald Trump certainly has one view. He has promised to, quote, shatter the deep state, bring independent regulatory agencies back under presidential authority, and restore government controlled by the people. Others disagree. Indeed, Justice Elena Kagan recently blasted this approach as, quote, a schoolhouse rock version of the separation of powers, instead favoring an approach where the Congress and President figure out what blend of independence will best enable agencies to perform their intended functions. Tonight, we get to debate, discuss, and decide for ourselves. To that end, we are hugely fortunate to have three brilliant legal minds with us. First, our incredible moderator who will set the stage, the Honorable Lisa Branch of the United States Court of Appeals for the 11th Circuit, and our two fierce debaters, Mr. Adam White of the American Enterprise Institute and Professor Noah A. Rosenblum of the New York University School of Law. But before we hear from them, I have the pleasure of introducing our moderator, Judge Branch, who will set the stage and introduce our debaters for this discussion. Judge Branch was appointed to serve as a circuit judge on the United States Court of Appeals for the 11th Circuit in March 2018. From 2012 until then, she serves as a judge on the Court of Appeals of Georgia. Prior to her judicial service, she spent her private practice career in commercial litigation at Smith, Gambrill, and Russell in Atlanta, rising first from summer clerk to associate, then to partner. From 2004 to 2008, Judge Branch was a senior official in the administration of President George W. Bush. She served first as the Associate General Counsel for Rules and Legislation at the Department of Homeland Security, and then as counselor to the administrator of the Office of Information and Regulatory Affairs at the Office of Management and Budget. After graduating from law school, Judge Branch clerked for the Honorable J. Owen Forrester of the District Court for the Northern District of Georgia. She earned her JD with distinction from Emory University School of Law and her BA cum laude from Davidson College. Thank you for coming, enjoy, and please extend a warm welcome to our amazing panelists.
Thank you all for joining us this evening for the latest installment of the Georgetown Law Federalist Society Daniel Webster Debate Series. If you go online, you'll see that it's the 12th debate that we've hosted since September of last year, with many more to come. The videos are up from the prior debates, and I highly recommend that you watch them. One of the important skills for all you law students, one of the important skills you should learn in law school is how to engage in a civil manner with someone with differing views. And this debate series presents an excellent opportunity to see two thoughtful perspectives on our topic. And Brady, thank you and your team for all you've done to make this event proceed so smoothly. So I want both for the audience to join me in welcoming our two scholars who will debate our topic, are independent agencies constitutional? Professor Adam White is a senior fellow at the American Enterprise Institute, where he writes on the Supreme Court and regulatory policy. He also serves as executive director of the C. Boyden Gray Center for the Study of the Administrative State at the Antonin Scalia Law School. Previously, he practiced constitutional and administrative law in Washington after clerking for the D.C. Circuit's Judge David Sentell, and he's long been active in the Federalist Society's programs on administrative law, and last year he chaired the American Bar Association's Administrative Law Section 2. And in 2021, President Biden appointed him to the Presidential Commission on the Supreme Court of the United States. Professor Noah Rosenblum is an associate professor of law at the NYU School of Law, where he works on administrative law, constitutional law, and legal history. His writing has appeared in leading law reviews, and he's won several prizes, including honorable mention for the Emerging Scholar Award for the American Association of Law Schools section on administrative law. He's also the faculty advisor for the NYU Law Review's Spring Symposium this April on the future of administrative law, which might be of interest to folks in this audience tonight. These gentlemen will walk you through the basics about independent agencies as well as their historical roots. They will explore the constitutional arguments for and against independent agencies, and we will explore how current events may shape the next legal battles about them. When I was invited to participate in this debate series, I was asked to choose the panel I wanted. I chose this one. Why independent agencies, you might ask? There are a number of thought-provoking issues being debated in other sessions. For example, should religious objections supersede anti-discrimination laws? Do DEI programs violate equal protection? Do universities fail to protect speech? To be fair, I wanted to do that one, but somebody had already chosen that one. Should the court overturn Bostock? But I wanted to talk about independent agencies because of my service in the Bush administration. I started off in the Department of Homeland Security supervising regulatory initiatives for the General Counsel's office. In that role, in what was at the time the federal government's largest rulemaking agency, I interacted with the Office of Information and Regulatory Affairs, which this evening we will refer to as OIRA. And OIRA is the gatekeeper of federal regulations. As an executive branch agency, Homeland Security sent most of our draft rules to OIRA for review prior to publication. Having experienced regulatory review from the agency side, I then moved to OIRA, where I served as counselor to the administrator, overseeing regulatory review for not just Homeland Security, but all of the federal cabinet agencies. For those of you unfamiliar with OIRA, it is housed within the Office of Management and Budget, which is within the Executive Office of the President. It is often referred to as the most important government office you've never heard of. OIRA performs many functions regarding oversight of executive branch regulatory administration, two of which I'd like to highlight: regulatory review and interagency coordination. Anyone involved in the regulatory world is quite familiar with Executive Order 12866. Under Executive Order 12866, which was signed by President Clinton, for significant agency rules, and those are rules having an annual effect on the economy of $100 million or more, the agency must prepare a cost-benefit analysis and submit the rule to OIRA review. As part of OIRA review, OIRA brings together other agencies and stakeholders to provide input on the rule, as regulations often affect more than one department. For example, the Department of Homeland Security was tasked with putting out a regulation on chemical facilities. That sounds straightforward enough. But when facility was defined as any place where a certain threshold amount of certain chemicals were reached, it implicated farms. It implicated chemical labs in schools, in universities. And it implicated any trucks hauling chemicals across the country, and it implicated trains, just to name a few. So what OIRA did was OIRA pulled together the interagency review process, but also brought in very public meetings that were disclosed, brought in the private sector to give input on those rules. That's the function of OIRA review. Executive Order 12866 covers federal government agencies, but it exempts independent regulatory agencies. Why? Not because the president didn't believe he had authority to review rules promulgated by independent agencies, but it would have been a political fight, and at the time, there was a perception there might not be a pressing need to pull in independent agencies. So why does OIRA review matter? OIRA review ensures that the federal government is careful when regulating. Keep in mind, OIRA is reviewing rules with at least $100 million in effect on our economy. OIRA review ensures the rule is thoughtful, narrow, and legal, that the rule has been vetted by the other agencies who will be affected by it, and not only that a cost-benefit analysis is performed, but performed well. OIRA ensures that the government issues rules it needs to, but does not over-regulate. So even though independent agencies were exempted from Executive Order 12866, OIRA kept discussing the possibility of reviewing independent agency rules and the growing need to do so. The independent agencies were increasing in number, their rules were imposing great costs, and other agencies could provide valuable insight if afforded the opportunity to collaborate during OIRA review. In fact, in 2011, President Obama issued an executive order that encouraged independent agencies to voluntarily follow Executive Order 12866. But to date, independent agencies have not been compelled to do so. There are two recent developments worth noting. First, in October of 2019, which was toward the end of President Trump's first term, the Department of Justice Office of Legal Counsel issued an opinion concluding that the president may require independent agencies to comply with the centralized review of Executive Order 12866. And second, we're about to start President Trump's second term. It will be interesting to see if one of his early executive orders addresses this issue. As you can see simply from the tension within OIRA, independent agencies present challenges. Justice Thomas has phrased the issue more bluntly. In his partial dissent in the Supreme Court's 2020 decision in Scalia law about the unconstitutionality of the structure of the uniquely organized Consumer Financial Protection Board, he said, because independent agencies wield substantial power with no accountability to either the president or the people, they pose a significant threat to individual liberty and to the constitutional system of separation of powers and checks and balances. In his dissent, he called for the court to overrule Humphrey's Executor, a 1935 case allowing a congressional restriction on the president's power to remove an FTC commissioner. And in the Scalia law, majority had simply refused to extend Humphrey's Executor. So will Humphrey's Executor fall? And if it does fall, what will be the fate of the independent agencies? And with that, let's begin our debate. So why don't we just start off with the basics? When we discuss independent agencies, first of all, what do we mean? What are the independent agencies? If you Google it, that is actually a rather difficult thing to pin down what agencies fall under that title. But what do we mean by independence?
Who's first?
We'll start with you.
I just want to say right off the bat, thanks in addition to Professor Rosenblum and to Judge Branch, I want to thank the Federalist Society and the Arthur Rupe Foundation for supporting this. Noah, I call Noah, we're friends. We were joking beforehand, what if, or not joking, but actually saying, what if we switched sides in the debate and tried to argue the other side to really show lawyers how it's done, and then we realized we'd never be welcome with our friends ever again. Sorry, Judge, I didn't mean to filibuster. When we say independent agency, what we mean specifically, and especially in this kind of debate, it goes to the legal independence of the agency from the president. Statutes that create a measure of independence for the decision makers at the agency, at the top of the agency, insulated against the president. Oftentimes other agencies have a sense of independence. It's often said the judiciary, the Justice Department has a sort of an independent spirit to it, or norms of independence. That means different things. But here we mean, and I'll tip my hand with the answer, we mean agencies that Congress vests with legal protection to push back from the day-to-day management of the president and make decisions that are not as directly accountable to the president as the rest of execution. As you might tell from that, I think they are unconstitutional in their present form. And I think we will get to that point someday where the Supreme Court overturns Humphrey's Executor. But it's taken a long time for us to get to a point where now the status of these agencies makes them, in my opinion, unconstitutional.
So let me just pick up there. And I also just want to take a moment to thank Brady for the incredible organization. Thank you, Judge. Thank you, Adam. Adam and I are friends, but for the purposes of this debate, he will be my most violent, despised enemy. And I'll try to bring that spirit of...
A lot, actually, yeah.
of zealous advocacy. And so in that spirit, I'm going to start in zealous disagreement with Adam, and I'm going to do that by saying, I agree with you that when we're talking about independence, we're talking about independence from the president and the ability to push back. But in order to understand why independent agencies are in fact constitutional, we need to dig into the different degrees or factors of independence, the different aspects of independence, because what does it mean to push back against the president? So I suspect we'll get into this more, but one aspect of that, and this was obviously front and center in Humphrey's executor, is removal authority. Can you be fired? So that's one question. But as everybody here who's ever employed someone else knows, firing someone is an awfully blunt tool to try to exercise control. And even if you think the threat of firing is a way of trying to exercise control, it doesn't guarantee that you can step into their shoes and exercise control on their behalf. Certainly, President Jackson didn't think so when he was trying to pull the funds out of the Second Bank of the United States. So if it's not just removal, what else could independence be? So there's a great article by Kirti Datla and Ricky Revesz where I'm getting some of these ideas from, but they flag a few different aspects, including, importantly, something like litigation authority, or, for example, policy-making authority, or budgeting authority, or the ability to communicate directly with other actors besides the president. And so that I don't go on, I'll just submit, for the purposes of this debate, that depending on which kind of independence you're interested in, the constitutional arguments for it might be much stronger or weaker. So it's much too simple to say, as someone might say, that independent agencies are unconstitutional. You got to talk to me about what kind of independence and what makes that independence legally problematic.
And could you just give us an example so that the audience is on the same page, sort of give us examples of the ones we all know about that are independent agencies, but maybe some that people aren't aware of?
Well, so
it's a long list.
It's a long list. And just as the judge was suggesting, there's no single list you could get to. So one way of making a list would be to start where the judge did and think about what agencies are not currently subject to OIRA review. But that's while that's probably a good way to do it, if you're a constitutional originalist, that's not super helpful because the Constitution doesn't tell you anything about OIRA. So you couldn't look to that for guidance. Another way of going might be to say, which are the agencies that have multi-member commission heads that are not removable by the president? And that's kind of a Humphrey's executor way, and that would be, I don't know, the smallest, most classic set. And that's going to include some agencies that we know, that we all kind of agree are independent, like the Federal Reserve. But it also brings in some agencies that you might not think of as independent. So the agency at issue in Humphrey's executor was the Federal Trade Commission. And this is an example I love to talk about with my students, because on the one hand, it's an independent agency under the law. On the other hand, if you look at the policies of the FTC, boy, do they sure seem to track the policies of the president. And so to what extent does that mean they're independent?
Where does the notion of independent agencies come from? Were there independent government departments in the founding era? Are these more of a creature of sort of the modern era?
So I'm a legal historian, as the judge mentioned, and so as I like to tell my students, everything in history is continuity and change. So on the change side of the line, I think it's pretty fair to say that independent agencies as a modern phenomenon are kind of coeval with the idea that expertise has a particular contribution to make to government that should be independent of politics or removed from politics. So I mentioned the Federal Reserve, right? One of the arguments for Federal Reserve independence is we want the people making decisions about the monetary supply to be doing so on the basis of technical considerations that shouldn't be subject to politics. Many administrative law professors would say the first independent agency is the Interstate Commerce Commission, which was similarly about a group of experts to regulate railroad traffic. But in the spirit of debate, I would say there are obviously continuities that precede that. So two small examples. If you're interested in agencies able to make their primary decisions without being totally controlled by the president, you could go all the way to the founding to something called the Sinking Fund Commission, which Christine Kexel-Shabbat of Marquette Law School has written about, which is a body that includes people from all three branches of government to make decisions about managing the national debt. So that's at the founding. The president can't do whatever he wants with it. It's got a will that's kind of its own, and it sure looks like an independent agency. On the flip side, another early example, if you want to go with independent litigation authority, it's like shooting fish in a bucket because there wasn't centralized control of federal litigation at the founding. You could hire a private federal prosecutor to go pursue a crime on your behalf. People were doing it part-time. The Attorney General didn't supervise U.S. attorneys. So that would be an example where all federal litigation at the founding is necessarily decentralized and so has an aspect of independence.
I just want to say there's a lot I agree with sort of in the factual premise of this, that in the founding era, there were parts of government, even parts of what we'd now call administration, that had a lot of independence from the president, right? For example, most famously, since you mentioned the Fed, there's the first Bank of the United States, right? Created by the first Congress and signed into law by President Washington. Anything President Washington signed into law tends to get the benefit of the constitutional doubt from me. And today we can analogize it to the Fed, but in the first instance, what was it? It was a corporate body chartered by Congress to wield significant power in day-to-day life. Now we've come to think of it in some ways, now the modern Fed has regulatory power. Bank of the United States, significant, not necessarily a regulator. When you get into the middle of the 19th century and you get past things like the Steamboat Commission, into the in the Interstate Commerce Commission, you get these agencies, these commissions arise. They're called then commissions. And interestingly, they're created not so much to take power from the executive branch or to be a competitor to the executive branch. If anything, they were created to take power away from the courts, right? Things like the Interstate Commerce Commission created to be a sort of a fact-finding and policy-setting body in lieu of policy-making in the courts. Now, you get it especially into the 20th century, and a lot of these things begin to converge. Things like now the Federal Reserve take on more and more modern regulatory power. Over time, there isn't a whole lot of difference between the way the Interstate Commerce Commission goes about its work versus the Federal Trade Commission versus the Environmental Protection Agency. So you do get a lot of convergence at the end. In the beginning, these things are coming from very, very different places. And for me, the question at all stages for purposes of a conversation like tonight is, it's not so much executive or independent agencies. Is the power that the agency is wielding, then or now, executive power? And if so, is that executive power subject to sufficient control by the executive, by the president? And so those are the sorts of distinctions I draw in that evolution of history.
So if we look at that our government we have three branches of government. What is the rationale for an independent agency, and what are alternatives to independent agencies?
You're not going to like my answer. You go first on this one.
If I'm not going to like your answer, I feel like you should have to go first.
Why don't you at least make the case for them, and I can maybe quibble a little bit.
Okay, so the first thing, and I'm sure the judge will not like what I'm about to say, which is, where does the Constitution say that there are three branches and only three branches? Right? There is no separation of powers clause in the Constitution. And this is worth hammering home because, of course, when the Constitution is drafted, they could have included a separation of powers clause if they wanted, since the Massachusetts Constitution had one explicitly and served as a model. So the decision not to include a separation of powers clause has to tell us something. You could even go further if you wanted, right? Madison in the Federalist Papers says explicitly it's impossible to draw a strict separation between the three branches. The idea that you could create a conceptual category of executive power is something that someone as brilliant as Professor Adam might be able to do, but it's not something any of the founders felt capable of doing, which is why they didn't include it in the Constitution. So if that's going to be our approach, we have to have a different frame for thinking about administration. Now, just because there is no separation of powers clause doesn't mean the United States Constitution doesn't embody a commitment to separation of powers and checks and balances. It certainly does, and that's critical. And the reason we have that is for all the reasons we learned in grade school and that you can get from Montesquieu, who's the most quoted, right? And it's all about creating what Montesquieu calls secure liberty, secure freedom. And if you're worried about security in your freedom, you might be worried about anyone with the power to tyrannize over you, whether that person is a court or a Congress or a judge or an expert administrator. So from that perspective, I would say there are two key pieces to the defense of independent agencies. The first comes out of the observation that Adam made that I totally agree with, which is that initially, many independent agencies were created as kind of alternatives to courts or technical courts. And we can talk more during the Q&A about why regulated parties might want that. But if that's your vision, right, what you're trying to do is to get into a forum that is going to give you a better, fairer, sophisticated hearing than you might get somewhere else. And it's easy to see why, for example, the Interstate Commerce Commission might be better placed than some generalist judge, my apologies, Your Honor, to decide on a really technical question like railroad regulation, right? So that would be one defense of independent agencies, more secure freedom by getting a better forum. Another defense of independent agencies, and we see this one emerge more at the end of the 19th century as government gets asked to do more of these complicated technical issues, is that we might want to create kinds of checks and balances inside the government itself. So a key idea behind many of these reformers who are pushing what becomes the modern administrative state is the distinction between politics and administration. You might want fundamental political decisions about what we do together to be decided by people who are directly elected by the people. But actually carrying those decisions into practice, that's a different kind of skill, and it might draw its democratic legitimacy from a different place. If you're in that second category of administration, you might want to consign the decision to a body that enjoys forms of independence and protection. So it's in service of the same goal of separation of powers and checks and balances. We're trying to get secure liberty, but secure liberty in the context of effective government can be a case for independent agencies.
And again, maybe to go back to the very beginning of it all. When you think about, say, the Bank of the United States, am I in favor of that both as a constitutional matter and just as a policy matter? Yes, Hamilton was right. The Bank of the United States was not just a good thing for the original government to have, it was an utterly necessary thing for the original government to have. And I'm fine with it because it didn't exercise executive power. Same with the early Interstate Commerce Commission, a specialized fact-finding and to some extent policy-making body that would serve in some relationship with the courts where it might get the benefit of the doubt on facts or something. I'm fine with that. I disagree with most of the rest of my friend's answer. Let me tell you though, when he started, he made a reference to Madison, where Madison said it's impossible to draw lines between the branches of government, perfect lines between the branches of government. Does anybody know where that line comes from? It's my favorite Federalist. It's from Federalist 37. Since there's some students here, I want to go on for just a second here. The original Federalist is published in 2 volumes. Federalist 37 is the first essay in volume 2. After having spent the first 36 essays explaining the problems with the existing arrangements in government and the threats the nation faced and the need for a new form of government, Volume 2 defends the Constitution that the founders wrote. And Federalist 37 is my favorite paper in all of the Federalist because there Madison says up front, what we're about to describe is extremely difficult and it's not perfect. It's impossible to draw perfect lines between the different species in the natural kingdom, and it's nearly as hard, maybe just as hard, to draw lines, perfect lines, between the 3 parts of government. What he doesn't say, though, is we shouldn't try. And the rest of the Federalist is an effort to defend the lines they drew in that document. There's no theoretical perfection, but it's important. And it's important here why, and this is where I get to the real point of the question. We don't have the separation of powers for its own sake. We don't even particularly have it just for like some vague notion of checks and balances. We have it because good government, as the Federalist explains, requires 3 things. At risk of being pedantic, it requires legislating, it requires execution, and it requires adjudication for cases. And those 3 things, there are 3 different powers that require 3 different approaches to government, to action. It requires 3 different kinds of qualities of character in the decision makers. What makes a good judge is different from what makes a good president, what makes a good legislator. In the case of the executive, and this is where I do think the Federalist does make clear, and the Constitution in the vesting clauses makes clear there are, maybe if you call them 3 branches of government, 3 kinds of power that must be kept separate as much as possible, is that to have good execution, which is necessary for good government. The true test of a constitution, Hamilton says twice in the Federalist, is good administration. It has to be energetic. It's going to require discretionary judgments that are not always easy to justify with like a written opinion. So there has to be accountability. People have to know who is responsible for individual decisions. and it requires a character of faithfulness in executing the law. That's part of that accountability. So that's why there really are three parts of government, because it's three kinds of government action requiring three fundamentally different qualities of character in government. And for execution, all of the things we're going to discuss tonight about independent agencies, different forms of independence, splitting them up into 5-person multi-member commissions, keeping things at bay from the president, as long as we're talking about execution, all of those things actually degrade execution, and that in turn degrades constitutional government. That's my main point tonight.
So we've mentioned that some of the debate about independent agencies focus on the removal power. Why is that, and on what considerations does this debate turn?
I just filibustered, so I feel bad going again, but I'll go again. Because here I think Noah and I probably agree. The removal power has been the central forum for litigating the nature of presidential power and the power of the president over other parts of the executive branch, right? And not just, it didn't just start in the famous Myers versus United States case where Chief Justice Taft, who knew a thing or two about how hard it is to be a president, so the president has to have total power to fire the postmasters. Thank goodness, right? Now that's why the postal system is so great now. But then from there to Humphrey's executive, the case about the FTC, Weiner versus United States about the War Claims Commission, and on into modern cases like Scalia law and so on. They've all centered around removal because, as Professor Rosenblum pointed out earlier, that is seen by and large, accurately or not, as the main tool a president has for ensuring that the job is done well, either sort of threatening implicitly or explicitly in advance, if you don't do the job the right way as I see it, I'm going to fire you. And then, if he needs to fire somebody, to create space then to bring somebody as quickly as possible in through appointment. So removal isn't the exclusive forum for fights over presidential power and independent agency independence. There are, as Noah said, many other sort of qualities of agency independence that might deserve more attention. But this historically has been the central forum for litigating the nature of executive power.
And just to maybe add a thought, and it helps, I think, explain some of why it is that Adam and I can both disagree on particulars while agreeing about the kind of conversation we should be having. We talk about the removal power, and we talk about the sort of principles of good government because there isn't that much constitutional text to work with. So we have the vesting clauses. There are some other clauses we can get into, but you'll look in vain in the Constitution for a removal clause. And yet it's clear that someone has to have the power to remove people who work for the government. And so if we know that there must be this power, someone's got to be able to remove folks who work for the government, but there is no text about who's got the power of removal, we're going to necessarily get drawn into conversations about the vision of government, the plan of government, the meaning of executive power. Many of our disagreements would not come up if we were looking at, say, a state constitution, because a state constitution can go into a lot more detail about the structure of the branches that are not the legislative branch and the judiciary. Because the Constitution says so little about the government and how it should be set up, and even less about what's come to be called administration, we have to talk about these issues. Removal is one of the ones that comes up first, right? Because we're history nerds, right? Adam alluded to the Myers decision. The Myers decision spends a long time talking about something called the decision of 1789, or Jed Sugarman has recently called it the indecision of 1789. It's a debate that happens in the first Congress about how to structure some of the first departments of government, and the question of removal comes up right then, and they debate it and confront this very absence and start wrestling with it. So back to the judge's point, right, part of the reason we fight about removal is because this question of how to structure the government is there from the beginning, and there's an absence, and so we have to figure out what to put there, but the issue of control, of firing, just can't be avoided.
You've mentioned the Supreme Court's 2020 decision in Scalia law, and the Supreme Court wades again into the dispute over the president's removal power. And in that, Chief Justice Roberts wrote the majority opinion, discusses Humphrey's executor a lot, and doesn't find a need to overturn it. But Justice Thomas, in his partial dissent, spills a lot of ink talking about why, in fact, it's a terrible decision and needs to be overturned. What's next? If that case did not present the opportunity, does that mean, what's your prediction? Do you think the court is waiting for an opportunity? Do you think Humphrey's executor will fall?
It'll fall someday. You know, it's an interesting time to see these issues litigated, because while we're now decades into the modern argument over the constitutionality or unconstitutionality of these removal statutes. Again, not for the first time. I think later we'll probably talk about how some of this echoes the debates from, again, FDR and the FTC. We're now 40 years into really debating it in the modern era. And even while there have been calls from Thomas and others to begin things from the ground up and start with constitutional first principles and constitutional text, in spite of precedent, there still are a number of justices on the court, including the Chief Justice, who are reading it through the other end of the telescope in some ways and saying, we have this body of precedent. What can be decided in a given case without taking the rest of it down, right? We now have had 2 or I guess 3 major cases about the removal power. The big one is Seal of Law with the CFPB. Before that, about a decade earlier, you had a case involving an accounting board that operates within or underneath the SEC. It was created by Sarbanes-Oxley. In both of those cases, the Roberts Court, I think both in opinions written by Chief Justice Roberts, said this particular thing we're looking at in this case is unconstitutional, even under existing precedent, right? In the case of the CFPB, you have an independent agency that isn't even one of these 5-member quasi-legislative, quasi-judicial boards that were affirmed in Humphrey's executor. Here, we're going to say, because Congress went even beyond the line that the Supreme Court drew in Humphrey's executor, we can at least strike this down. Same thing with that case a decade earlier involving the accounting board. It was characterized, I think rightly, as an independent agency within another independent agency. And the court said, again, we're not going to overturn Humphrey's executor today, but we're not going to allow Congress to go further than Humphrey's executor either. So every time Congress has created, in the last at least 20 years, sort of a novel and significant variation that's seen as going beyond Humphrey's executor, the court will continue to strike that down. I do think it's only a matter of time until they are confronted with the core question. The case that I thought might bring this up, I love this case so much, it was a case involving Walmart. The Federal Trade Commission brought an enforcement action against Walmart, I think in the Northern District of Illinois. And Walmart, in their defense in the case, said, hold on a second, FTC. As everybody knows, haven't you read Humphrey's executor? You're a quasi-legislative, quasi-judicial commission. You're not an executive agency. You can't wield executive power. Therefore, trying to bring this enforcement case against us is an unconstitutional exercise of executive power. I kind of wonder if the case that really ends up relitigating the core issue, it will be framed in those terms of a so-called independent agency wielding executive power, and it becomes more a case about that executive power rather than about the structure of the agency.
So I know this is supposed to be a debate, so I should find something in what Adam said to disagree with. The only thing I can find to disagree with is the logic the court is using. I don't think it's just about going after novelty, but there's a lot to that position, including a wonderful article by Leah Littman about the court's real suspicion of novelty. Just to maybe pick up on a thought of Adam's and draw it out, particularly for the students in the room, right? The justification of Humphrey's executor is that the FTC was operating as a quasi-legislative and quasi-judicial body. And I do think it's fair to say that that rationale has been abandoned. In fact, I think it would be challenging to reconstruct it. As a legal historian, I can kind of do it for you, and it's connected to the point that Adam made about the way that these commissions were operating as alternative to courts. And there's a vision that the commission was really giving information to Congress or something like that, but man, is it a stretch. And you see this in the court's jurisprudence post-Humphrey's executor, where I think it's in Scalia law, there's a footnote that Roberts drops where he says something like, well, the defense was that it was quasi-legislative and quasi-judicial. Man, this sure looks executive to me, but I'm not going to deal with this now. So once you abandon that rationale, what's left of Humphrey's? And the answer is basically a bright line rule, and the bright line rule is kind of incoherent. So after Scalia law, the rule is something like multi-member commissions are allowed because the president can exercise some control by appointing people, but they're deliberative, so it's okay that the president can't control them. But for what it's worth, that's an even more tension with the kind of vision that Adam is laying out for you, in which you need executive power. Obviously, for my vision, that's not a problem at all, but I do think the court is with Adam on this one, which suggests to me that they've already abandoned Humphreys by turning it into this kind of bright line rule, and so it really is just a matter of time. Now, you might ask, why haven't they overruled it yet? And I think the answer is because the bright line rule is still doing a lot of work for us. In particular, if you get rid of Humphrey's executor, you need a different reason to explain why the Federal Reserve's control of monetary policy can be independent from the president. And I will say there are law professors who are working right now at coming up with a bespoke rule that is grounded in some of the interpretive principles the court has announced for why you could overrule Humphreys but not have to strike down the independence of the Fed. I tend to think of that as a kind of legal ledger domain, but obviously that legal ledger domain may be what maintains the solvency of the American monetary system.
How recently has the constitutionality of independent agencies become a subject of debate? Why are we arguing over this now, and have liberals and conservatives changed sides?
Can I take this one? Because this is one of my favorite little things to harp on a bit. So if you think about, right now, as Brady, I think, really beautifully framed the debate for us, right now part of this conversation happens in the shadow of the fears of the deep state. And we can all remember, it wasn't all that long ago, during Donald Trump's first term, there was a lot of writing about the deep state being captured by liberals who were undermining his Republican conservative project. I think it was just last year, 2 years ago, the historian Beverly Gage published this riveting biography of J. Edgar Hoover. It won all the prizes. I highly recommend it. And if you read it, two things will immediately jump out at you. First, that J. Edgar Hoover is the deep state. He is the biography is called G-Man, right? The FBI and the world that he built, and not just in the sense of like the deep nefarious security apparatus, but all of the virtues that I've been talking about for independence. Expertise, professionalism, hiring a staff that's going to work. That's his vision. That's what he's doing. And J. Edgar Hoover is the most conservative man in America. He is widely celebrated for his conservatism. He's a conservative hero and icon, and his vision is inextricable from the deep state. So in fact, for a lot, and this now gets into my particular area of historical interest, so you'll forgive the excitement, but the people who are pushing the construction of what becomes the modern American government at the turn of the 20th century, it's Republicans, and it's not just Republicans, it's William Howard Taft, it's Teddy Roosevelt, it's people who we can think of as heroes of the conservative movement. And so the opposition to that is coming from the Democratic Party. So now it seems obvious that commitment to the deep state is a liberal priority, and if you're a real conservative, you have to try to root out the deep state. But for most of the history of the state, it hasn't been that way. So why are we fighting about it now so much? I think there are a lot of different factors. I've gone on too long, so I guess I'll leave those for Adam. But I'll say I think it's inextricable from some current political fights that, for whatever reason, have been raised to a constitutional level. And that is really exciting, and I don't mean to diminish it that way, right? It connects to debates that happen inside the Reagan OLC, and there are real constitutional questions here. But when you can't resolve your problems through other means, when you can't pass legislation, when you have to make appeals to the Constitution to sort of win your fights, you have to reframe what are really partisan political disagreements as if they touch on fundamental questions of state organization. And that may or may not be the best way to go about thinking through the prerequisites of good government.
You don't know, with all this talk of J. Edgar Hoover, as soon as this event's done, we need to go down the hall to the bar at the end at the hotel, which is literally named Edgar after J. Edgar Hoover. He used to always have lunch literally at the room across the hallway here. Why is this an issue now in recent years? I mean, there's obviously any number of reasons, and some of them are going to be transparently political. And yes, a lot of it has echoes, direct echoes, of FDR and what he tried to do now almost a century ago. I once, in an edited volume, when I was tracing the history of independent commissions, I had a little subsection titled, Reaganite Ends by FDR's Means. Like, yes, the Reagan administration was adopting FDR's constitutional arguments. And just because they're FDR's arguments doesn't make them wrong. The reason why I think they reemerged with such vigor when they did, at least the two, I think, best reasons why are these. First of all, it was part and parcel of the return to the original meaning of the Constitution, the spirit of the founders, the intentions of the founders, right? We're now coming up next year on the 50th anniversary or the 250th anniversary of 1776, the Federalist Society and other organizations emerged in the immediate aftermath of the bicentennial in this middle of this outpouring of attention to and even affection for the words of the founders and the ideas of the founders. And by 1976, the system of administration we had bore increasingly no resemblance to the actual three parts of government, three powers of government. Frankly, the executive power debates were some of the lowest hanging constitutional fruit for debate around what had gone wrong with modern arrangements in government. But second, and I think it's very important, and this will sound more partisan, and maybe it is, but I don't think it is that when President Reagan came to office, it was clear that modern administration was bogging down under its own weight, that it was increasingly impossible to actually reform administrative policy. Now, a lot of administrative policy was now just outright lawmaking through reinterpretation and through new rules and so on. But the Reagan administration and my old mentor, the aforementioned late C. Boyden Gray, they came to office and said, surely there has to be a way for the president to actually oversee the executive branch, right? In the aftermath of the Carter administration, in which it was debated whether the presidency had become too big for any single occupant. And Reagan's argument was, no, it wasn't. The problem was not that the presidency had gotten too big, it's that the presidency had gotten too small in the overall system of administration. So between this return to the thoughts of the founders and this focus on the problems of the time, which to the Reagan administration required a much more energetic presidency, that started a debate that now we're still having 40 years later.
Judge, can I sneak in a quick surreply? Just two sort of provocations, because I can't resist. One would just be, I love Adam's story, except of course the founders had really conflicted feelings about the presidency. Certainly the idea that the president was going to be directly elected to control the government and implement the People's Program, that was James Wilson's idea, and he loses at the Constitutional Convention. So they reject that pretty explicitly. And the second thing is that while it is true that the Reagan OLC is a space we start to get some of these constitutional arguments, I'm so glad you gave President Carter the shout out. A lot of these fights about regulatory control begin under Carter, and in the H.W. Bush administration, when they're talking about their deregulatory triumphs, they have to admit that the most important ones were won under President Carter. So the only problem with the story that Adam's laying out for you, he wants you to say, well, it's about going back to the founders to make a strong president to control the government, and I'm here to tell you, it's not about the founders, because the founders didn't want that, and it's not about the founders' bicentennial, because it begins before then.
Can I have a sir reply? This is so important. Thanks, Judge.
It is a debate, right? I'm sorry, Judge.
No.
The founders were tremendously worried about presidential power. What they were worried about was a king. They did not want one person able to make the laws and to single-handedly make and enforce laws. They didn't want a king. That's not to say they didn't want a president. And in fact, when they gathered in Philadelphia, and even before they gathered in Philadelphia, when Madison is writing his memo on the vices of government, so much of his concern about how things were happening at the federal level and even within the states, it was not just there's too much government, it was the opposite. It's too little government. Or there's what he would call mutable administration. Laws would be made and unmade, enforced, not enforced. There was no steadiness to it at all. It was just a mess, and it was oftentimes lethargic. It was bad government. It was the kind of thing that would cause people to lose trust in government. Even, by the way, even in the Declaration of Independence, while most of it is about the king doing too much, like the tyranny of the king, so much of it in the sort of the bill of indictment, basically at the end of the Declaration of Independence, is about the lack of day-to-day administration. It's that the king had deprived the colonies of steady administration within their own domestic governments. By the time they get to Philadelphia, one of the most pressing problems, especially in federal government, but even in the states, is the lack of good execution and administration. So, of course, the challenge for the convention is twofold. One is, how do we define and constrain this office, right? Both in terms of the scope of its powers and in the tenure of office. But second, and this is so important, is how do we create a system to bring people into this office with those right qualities of character that will make them the kind of person who we can trust, who we have to trust, with enormous discretion over enforcing the laws, right? The person who will swear that oath to take care that the laws are faithfully executed. Now, so much of the problem today is that all of the rest of that has broken down. We don't attract the right kinds of people to office anymore. When Hamilton says the Electoral College is virtually guaranteed to bring the right people to office, we look at that and we laugh now. It's a reason, though, to remember what this was all about, is that having a good president is essential and also incredibly difficult.
So we've talked about some of the reasons that the independent agencies exist, and we've talked about that presidents have a desire to have more power consolidated under them. What constitutional values does the unitary executive promote, and what danger does presidential power pose?
Yeah, I'll just, since I filibustered on this so much, I'll just recapitulate this. That one, you have to have energetic execution. Hamilton feared that the people would lose faith in government because laws will be enacted and then nothing would happen. They'd be enforced or not enforced. Nobody could plan their lives because nobody would know what the law actually was in effect. It's not to say the president needed to write the laws. It's that you needed steady, energetic administration. And then coupled with that then is the other point. You needed responsibility. You needed somebody to be able to, you needed whoever was electing the president, originally the original form of the Electoral College and now the more popular version of it, with all of us voting. You need to make sure the voters know who to hold accountable. Because actual execution, actual administration, as the founders saw it, not making all the laws, but enforcing them, was going to require enormous discretionary judgments that couldn't be reduced to like legalistic arguments all the time or like long regulatory impact statements as we have now. Ultimately, it was going to require just basic gut instincts and wisdom from presidents in deciding how to enforce the law. And then in turn, the voters would decide. Again, not having to make elaborate arguments or rationalizations, just say, I pick this person, not that person. And independent agencies, they corrode all of that, right? By making it harder for the president to say, well, this person's in, this person's out. Or making it easier, by the way, for the president to say, oh, I didn't like what this agency did, but it's an independent agency, and I'm not supposed to micromanage it. All of it in so many different ways disperses and dilutes the kind of accountability you need so that presidents can execute in the right way and then voters can make their own judgments in the right way.
So I guess it's then on me to talk about the dangers, and let me flag just two dangers. The obvious danger, the one we're all thinking of, is a president with that much power also has the power to trench profoundly on your liberty in a way that makes it almost impossible to push back. You want to talk about accountability? What sort of accountability do you have for a president who's in their second term and has the ability to control administration when your only meaningful checks are impeachment? No president has ever been removed from office as a result of impeachment. Or re-election when you have a president who's not eligible for re-election. So it fails on its own terms on the power issue, and on the accountability issue, it gets even worse. Because if you think about the two accountability checks are supposed to be this sort of election thing, and I just said that there are all sorts of contexts in which that breaks down. The other way is it presumes that what is actually happening in government is what you can hold the president accountable for. Now that might be an okay vision when the United States is 3 million people on the eastern periphery of a massive empire that it's a forgettable colony of, that it's just become independent of. But when you're trying to administer an incredibly complex regime, more responsibility can create less accountability, not more, right? The president has too many things on his plate to be meaningfully responsible for all of them, not to mention that he's going to be incompetent at managing most of them. You know, I was talking with somebody recently about a small tariff issue, whether bifocal contact lenses should be regulated as bifocals or as contact lenses. Now, this apparently is a complicated insurance question. It's also got some technical specifications. There are import-export responsibilities to it. There are prescription issues. Man, that is what I think about when I vote for the President of the United States, don't you? So the vision that Adam is laying out with all of this virtue, it's all lovely and attractive if the president is limited to dealing with a small number of questions that the people can genuinely hold the president accountable for. which is in fact the vision of administration as it gets developed. If you try to bring the independent agencies under the president, you wind up with the worst of both worlds. A president who is so powerful, he can trench on your liberty without recourse, and because of the profusion of tasks, incompetent and unaccountable simultaneously.
So now it's time to break out the crystal ball, and I'm going to ask you for some predictions as we sit here on the eve of President Trump's inauguration. What predictions you have that will touch on some of the independent agencies that we've discussed tonight. The first, I teed it up by talking about OIRA, and I think you had said you anticipate, at least potentially, that President Trump would pull them into OIRA coverage. But we've seen President Reagan didn't do that, President Bush didn't do that, President Obama didn't do that, President Biden didn't do that. Do you anticipate that President Trump will do so, knowing that there is a political fight that follows?
So I have to be honest, Judge, I don't remember if I said that I thought President Trump would or wouldn't pull it under OIRA, but I'm happy to
Or you teed it up
as
a possibility.
Absolutely. No, and I'm happy to, I appreciate the question and provocation, because I think there are two different pieces going on here that we have to disentangle. And the first is, there's something that tends to happen to government institutions, which is that they acquire a life of their own. And so even though OIRA began as a tool for expanding presidential control of the administrative state, OIRA now has its own quite professional staffers. And I feel sheepish telling you, Judge, because you have experience there. But my understanding is that OIRA has a very dedicated professional staff that is committed to implementing the will of the president, but simultaneously committed to what we might think of as traditional administrative values, like doing cost-benefit analysis according to defensible standards and following ordinary processes of the chain of command and things like that. One tension that presidents always have is that if you have an already existing institution with its own norms, that can be a constraint on your power. So pulling independent agencies into OIRA review, it's not obvious to me if that operates to make the independent agencies more responsive to the particular will of the president when the president is contemptuous of the already existing established institutionalized structures, or becomes another tool that institutionalizes those agencies and protects them from the whims of a president who doesn't respect the traditional institutional structures of government. So with Trump, it presents an interesting puzzle, because on the one hand, President Trump has certainly suggested that he wants to make use of some of the most maximal interpretations of presidential power. And if that's the take, then you would expect him to pull the independent agencies into OIRA review, despite the fact that, as you've pointed out, many prior administrations found that it wasn't worth doing. On the other hand, President Trump has also signaled as aggressively as he can that he thinks the existing institutions exist to frustrate his ability to implement the will of the people. And his interpretation of Article 2, there was that line he had, I have an Article 2 and it says I can do what I want. And if that's your take, then OIRA is an ambiguous tool to use, because unlike people who are directly loyal to you or who work right in the White House office, OIRA is an institutionalized aspect of the administrative state. So I hate to give, if a student gave me this answer, I'd say, come on, young man, commit yourself. You can't have it both ways. But I guess my suspicion is that what Donald Trump will do to the independent agencies probably goes beyond pulling them into OIRA, because my guess is that what he wants is a more personalized form of control, and he may understand OIRA as a barrier to that control rather than a way to exercise it.
I mean, my guess is they will finally issue an executive order bringing the independent agencies' rulemaking activities into the OIRA umbrella. I think they'll do that much. I might be proven laughably wrong, 4 years from now. I think they'll do it, and I think they'll do it early in their administration. This has been gestating long enough sort of in legal circles and White House circles. I'd be surprised if at this point that they don't do it. And by the way, in the last year or so of President Trump's first term, he issued an executive order calling for greater due process protections in agency adjudications. I wouldn't be surprised if they extend that as well to independent agencies. I'd be kind of surprised, actually, especially with so many people who are sort of part of this administration, around this administration, who are so up in arms over not just the rulemaking activities of the SEC and the FTC, but much more, I think more directly, the enforcement and adjudication activities of those agencies. I'd be surprised if President Trump didn't extend the adjudication oversight and protections to the independent agencies, and if so, it would only make sense to also do it for the rulemaking agencies. Now, one of them, and we've already mentioned it, the one people bring up a lot as a sort of a danger case is the Federal Reserve. What does this mean for that? We'll see. On the one hand, to the extent the Federal Reserve is making rules, like actual regulations, I wouldn't be surprised to see that perhaps get rolled into the OIRA oversight framework, although maybe not. President Trump, I think in his President-elect Trump, in one of his latest interviews on the subject, actually backed off from some things that he and others had said about the Federal Reserve's monetary policy. In an interview, he said, "I don't think I should be able to decide this question." And I think this went actually to also removing the chairman of the Federal Reserve. But he said, "I think my voice should be heard." So maybe he's backing off on the Fed, but the Fed and the Bank of the United States before has always been a different and special case because so much of what it does isn't executive power, quite frankly. And so I don't expect to see all of that roped into White House oversight.
Do you have any prediction about the Federal Reserve?
I think Adam's on the money there, as it were. I agree. I think, and you're seeing this in the law professor world. So I referred before to the bespoke solutions folks are coming up with, and they tend to follow the line that Adam is suggesting, distinguishing the Fed's monetary policy from its other regulatory activities, including those related to rulemaking and enforcement. And so I suspect that we'll see executive orders and possibly even cases that try to follow that line.
It's a hard line to draw, by the way. Lev Menon of Columbia Law School wrote an article a few years ago saying you basically can't separate out the regulatory power from the monetary power. I'm not sure which way that actually cuts in the end, but I do think you probably can parcel these things out and should.
And we're going to open it up for audience questions, and you'll see there's a mic in the middle.
Not everybody all at once.
We've just covered the topic so thoroughly. Yes, sir.
Well, thank you so much for both speaking tonight. When I'm thinking about independent agencies, I'm starting to see, I think there's a lot of times where what we think of as an independent agency is then redelegating some of its power to what we might call a nominally private entity. And so, for example, I'm thinking of like FINRA with the SEC, USAC with the FCC, which we're seeing in Consumers Research versus FCC, the HISA authority with National Horsemen's Benevolent Association. And so for each of your respective positions, just maybe a short comment on whether you think that is a beneficial aspect of the independent agencies. But my actual question is, setting aside the court challenges to that, do you think there are mechanisms for the next administration to kind of maybe pull some of that power back into executive oversight? And if you have any crystal ball suggestions on whether those might be exercised if those mechanisms do exist. Thank you.
So I don't know. I know some of those situations better than others. I mean, going back to the New Deal, there was a case on point that Carter versus Carter-Cole that said you can't delegate executive power, you can't delegate legislative power to a private entity. So like, at least in theory, you can't just take the legislative power and hand it part and parcel to a private body. Now with things like FINRA, or say in my old area of practice in energy law, the NERC, not FERC, but another body that governs the reliability of the power grid. They're private entities that have a lot of oversight from other agencies, the SEC or the FERC or so on, and so those become much more complicated. There's also a problem from the other direction, which is there are so many aspects of life, and business and so on, just social organization, that weren't government to begin with, right? So the monetary policy. Banking had what we would now call sort of policy-making power, but it wasn't part of government unless it was literally the Bank of England, right? The Bank of the United States was separate from that. Over time, that becomes absorbed into government. Now it's impossible for us to not think of monetary policy as government policy. So many other areas of sort of commercial law that might have been the subject of contracts or torts, some much more private ordering, over time became absorbed into policy making. And by the way, also in this day and age, you see areas where even still nominally private activity is so enmeshed in just day-to-day relationships with government and the administrative state that it is hard to draw a line between what is an entity doing on its own, say Facebook, and what is it doing at the behest or under threat from government. We're going to see more and more cases like that. And I think those are going to be the ones that really challenge us to think about how to distinguish private activity from government authority and who's actually acting here.
Maybe just to piggyback on that, 3 thoughts. I think it's worth distinguishing the legal from the normative and from the question of independence. Because on the legal side, I totally agree with Adam, and I would say it even goes earlier, right? You've got not just like delegations, but reliance on private actors to do fundamental government functions from the beginning, in part out of necessity. So if you're thinking about the early federal government, the workforce is basically what, the post office and the Customs Bureau. And like the customs officers, they're overwhelmingly dependent on private merchants to self-police because they just literally don't have enough external revenue service officers. So the idea that getting private actors to do fundamental government responsibilities as a legal matter, I think it's got, almost unimpeachable bona fides. That said, as a normative matter, it's obviously raises a bunch of questions. So Carter v. Carter-Cole, the question of private non-delegation. Also, just generally as an American citizen, it doesn't thrill me to think that fundamental government functions may be outsourced to interested parties. But that then takes me to the last factor, the independence. Does the particular fact that some independent agencies are doing this redelegation matter? And I don't know, right? In the 1960s, there was a huge debate about regulatory capture, and that wasn't just focused on independent agencies, that was a broader consideration. And so if we're thinking about whether they're advisory bodies or executive branch agencies or independent agencies, I think this anxiety that you might have private parties wielding unfair and disproportionate influence in decisions that should be made in the public interest is a real normative consideration that we should worry about, even if the legal question may not be front and center.
And by the way, since we talk about how these arguments come up on different political sides over time, we're going to see a lot of the arguments that we just discussed aimed at the Doge, right? There's going to be enormous questions over how this group of private individuals, to the extent it stays outside of government, to what extent are they wielding government power? Are they subject to the Federal Advisory Committee Act, FOIA? To the extent that they are totally separate and private and agencies end up doing things consistent with their recommendations, there's going to be enormous questions under the recent, the old census case from about 10 years ago, the Department of Commerce case, over what the agency did is actually, its explanation is pretextual and really masks a deeper relationship between what that agency is doing and what DOJ recommended, either publicly or not. We're going to have enormous questions about the relationship between the public sector and the private sector in the next 4 years surrounding DOJ.
Yes, sir.
Given the scope of modern civil service protections, to what extent would it be fair to characterize all of the government agencies as independent for purposes of today's discussion?
I've tended to resist the notion, the argument, we'll say this way. This comes up when the Supreme Court struck down that Sarbanes-Oxley board 10 years ago. I think Breyer in his dissent says, this puts the entire civil service at risk. I don't think that's true. I don't think the argument for executive power, even the argument I make, inherently carries all the way down to the bottom level of federal employees. Because again, the question is not what agency is their employer, right? It's about what kind of power is that agency wielding and what kind of power is that person wielding within an agency. So I don't think the arguments I'm making for executive power carry all the way down through civil service. I actually think the original civil service laws, the Pendleton Act, were good laws. I think we'll now litigate where that line should be drawn. I mean, I think Schedule F drew a good line, focusing on actual policy-making individuals. But I don't think, well, I see what you're getting at, and yes, people within the agencies in the civil service, they have a lot of independence of a sort, and often it's used to, I think, to make or to have a significant influence on policy, and I think it's worth taking a hard look at that. It probably would overstate it to say that the civil service it makes all the agencies in effect independent. I would push back against that a little bit.
So I agree with Adam's conclusion, and I suspect we might disagree about some particulars, but largely we're on the same direction. So 2 quick thoughts. I believe that the already existing statutes they extend much fewer tenure protections to individuals as a matter of law, never mind Schedule F, who are classified as policy-making actors. And so even under the existing statute, the attempt is to reconcile a professional civil service with the kind of executive energy that Hamilton would have wanted. And I think that if you are really committed to the kind of presidentialist vision, I'm not going to attribute it to Adam, but that Adam has suggested could be attractive, having the kind of professionalized staff that the Pendleton Act, the original act creating the civil service, envisioned, enhances that rather than undermines it. The second point, and this is an empirical observation, the Partnership for Public Service routinely conducts surveys of people in government and outside, and I believe, this isn't really my area, but David Lewis at Vanderbilt has written about this, I believe that basically managers inside and outside of government report about the same level of frustration with their employees, about the same ability to fire low performers, about the same sense of resistance. So that makes me think that actually the thing doing the work here isn't really the civil service, that basically private managers and public managers have the same experience, even though we spend a lot more time talking about how hard it is to fire public servants.
I mean, wouldn't the logic of that, though, be that we could just get rid of the civil service laws altogether and it wouldn't make a practical difference?
If we compensated our civil servants like we compensated private sector individuals.
Yes, sir.
Yes, hi. Excuse me, Paul Kamenar, DC lawyer, and I'm also senior fellow of the Administrative Conference of the United States. I just want to compliment the panel here. This has been an excellent discussion, one of the best that I've heard, and I really appreciate it. You talked about the Federal Reserve, so I guess there's a consensus that there's been discussion, can the president fire the head of the Federal Reserve Board? And I guess you both would agree that he cannot, but you know, it gets into, in terms of the removal power, that's even in the other statutes, removal for cause, removal at will. And finally, the issue of the bureaucrats, the deep state, et cetera. There's a concept of submerged independent agencies where the rulemaking power is delegated to the career staff, and how that insulates things. That comes up, as a judge would know, in terms of the midnight regulations when there's a change of administration. So can you comment on any of those things?
I have to say the question, like the blunt question at the beginning about the Federal Reserve Chair, that one really gives me pause, because while a lot of what the Fed does, I don't think really is executive power. I don't think monetary policy is inherently an executive power. A lot of it is direct regulation of banks. And it's not a question I've studied. I'm open to the notion that the president would have constitutional power to remove a Federal Reserve Chair over the Fed chairman's exercise of executive powers. I hope he doesn't, even in some of the all but the worst cases, because of the destabilizing effect it would have on the economy and markets, I think would be disastrous. And I think, frankly, it's one of the reasons why President Trump has backed away from that in recent days. But as a matter of principle, if it was a dispute over regulatory actions of the Federal Reserve that really were law enforcement, in the nature of law enforcement, I think the logic of my position goes all the way through to the Federal Reserve Chairman.
So I totally agree with Adam about the constraint of politics. Many, many years ago, I was an intern on Capitol Hill, and as you can imagine, I was obsessed with congressional procedure, and I remember meeting with someone from CRS to talk about the real power of procedure, and she pulled me aside and said, you know, you naive summer child, power is what matters, and procedure can be used in terms of power, but never lose track of the power. And so I think the point that Adam just made, that as a practical matter, given the way the Fed operates and its close connection to financial markets, that provides one of the few genuine power constraints on the presidency. And that, I don't know that I want to like hang the structure of good government on that, but I don't think we can engage in serious constitutional analysis without keeping that in mind. And that takes me to your second question about submerged agencies. So part of why I admire the founders is because they were eminently practical people. It's part of why they're thinking about power. My analysis in Adams fundamentally differs over how much weight we want to attribute to these abstract categories. I just don't think that talking in terms of an abstract category of executive power makes any sense, and I can talk about that more if you like. But once we look at things the way I would say the founders did, which is in terms of running a complete and effective government, then the question you're flagging of submerged agencies becomes both harder and easier. Harder because, in fact, actors who are in some way unaccountable but necessarily charged with government power proliferate. Right? None of us want an FBI agent to stop and call the president before they make an arrest just to make sure that they're really exercising the correct power. At the same time, none of us want FBI agents out there on the loose just doing whatever they want without guidance. So how do we figure out where to draw that line and to what extent? The submerged independent agency is a sort of extreme example of that. I tend to be less anxious about unaccountable government bureaucrats making rules at the last moment that defy anyone's ability to capture them, that affect our lives, mostly because there are other structures in place that enable forms of supervision and that enable that form of power control. But obviously we could disagree about how far that goes. So that's why it becomes an easier question, because I would say what we really need to think about is which rules, under what circumstances, and who are we worried about making them? Is it the Organic Foods Commission issuing a dangerous midnight order regulating exactly how much feed the chickens can get? Or is it, the people who are making fundamental decisions about what kind of health care coverage we can get or what sort of pollution can be emitted? And obviously, I will worry more or less about different ones. And just to be clear, I went to a school that was on a working cattle ranch. I am all about organic certification for foodstuffs. So I don't mean to trivialize that. I just want to suggest that we're going to stay up late worrying about some things more than others.
Can I quibble for a second? I'm sorry, but when you talked about the sort of the theoretical distinctions here, I think that overstates it. We're not just talking about theory. Like again, in Federalist 37, Madison sort of analogizes what we was talking about with separation of powers to, the division of species in the natural kingdom, right? Like the difference between a fish and a bird is not just theoretical, right? Like at some point, yes, you do have to draw theoretical lines and try to explain and rationalize the difference between a fish and a bird. But we can all look and say, even in the case of a flying fish, like there's a fundamental difference between a fish and a bird. There's a fundamental difference in the work of legislation, in the work of execution, and the work of adjudication, if only that the bulk of legislation, of course at the margins it gets difficult, but the main task of legislation is looking out into the future and prescribing broad laws that will generally govern people. At the other end of the spectrum is the work of adjudication, where judges are looking mainly to the past in terms of events that have occurred and have occurred and laws and precedents that have been written, and trying to judge individual cases looking backward. Now, in both those cases, of course, it's more complicated than that. Congress isn't just purely thinking about the future and in the abstract. And judges, when they're making decisions about events that have happened and laws that have been written, are doing it with an eye to how precedents will apply in the future. But the core of their task is looking this way and doing this, looking that way and doing that. In the middle of these two things is a president acting in the here and now, making decisions that are partly about the law and partly about their prudential judgments. But even in the middle of adjudication and legislation, the president's job is different. When Noah and I teach administrative law, one of the things that I always get a chuckle out about administrative law is the first half of the class is trying to analogize execution to legislation. And the other half of the class is trying to analogize execution to adjudication. Over the course of the last century, we've just lost a vocabulary for administration as administration, execution as execution in the terms of constitutional law. And I think in part it's because we've looked away from the qualities that are required in each of those judgments. The difference between a good judge and a good legislator is not just theoretical. There's a reason why John Marshall was the great Chief Justice, but kind of an average, good to average congressman. There's something fundamentally different about those two tasks.
Look, so just a small thought, I have to, because I so agree with the place that Adam is coming from, and I just this point about virtue, I could not agree with more. But I think that the distinction he's trying to insist on is too clear, and this will be a longer conversation, but we're not fighting about the core. The core cases are the easy cases, and for those who don't need lawyers, what we're fighting about are precisely the hard cases. And when we get into the hard cases, the history is much grayer. So Congress is about passing general laws, and yet in fact, the vast majority of legislation until, in historical terms, the day before yesterday, was private bills that applied to individual cases in which Congress was simultaneously legislating, executing, and adjudicating. They passed a law and made a fact in the world. And if we flip it around and think about this puzzle of adjudication, on the one hand, there is no doubt that the virtues of an adjudicator are different from the virtues of an administrator. And yet, the way that the trend of the executive power cases are going, it's going to pull a whole bunch of independent adjudicators under the executive branch. And so I just, we can have, maybe this will be a center for something at the Gray Center to discuss, but I don't think Adam and I are disagreeing, again, on the frame, but on how to bring that frame into application. Adam wants this to be a story of how we evaluate a bird and a fish. I want this to be a story about whether a whale is a fish. And do you want to let the future of the global economy turn on what the Supreme Court thinks about whether a whale is a fish or not? And I pick my example advisedly. There's a wonderful book about the history of adjudicating whether the whale is a fish or not. And for those of you who are going to stake the future of the global economy on it, I just want to know which way you come out so that I can buy some futures first.
And we have time for one more question.
So as you, Professor Rosenblum described, like sort of the discussion on the president's power over agency are mainly through removal. And then I do want to know if you see other ways where president can exercise control over agency except for through removal. I think there was an article done by Vermeil and Sustain, actually published, I think, at Georgetown Law's Review on sort of alternative ways, which is like so either through reinterpretation of INF or sort of through supervisory. So I have that pointed to, I guess, one subject at each of you, which is that, so in terms of redefining INF, do you guys see, seeing sort of adopting, if you don't go through our standard too much, that is going through the current administration standard too much, is that sort of a neglect of duty? And similarly, if we're, I would say that supervisory authority were to extend to a point where the president can reverse decision done by independent agencies, would that, in Professor White's view, make that constitutional? Because sort of in accounting board, the free enterprise case, the accounting board, the SEC can override the decision of the accounting board, but in a structure where the president or attorney general can override decision of the independent agency, would that make it constitutional in your view? So yeah, two questions.
So I swear the student isn't a plant, but it's a great opportunity to flog the article that I'm submitting this cycle, if any of you are on the Georgetown Law Review, in which we actually, my co-author and I tend to focus on Arthrex, which is a case we haven't talked about, but that raises this question of control versus removal as different ways of doing it. And I tend to think there is a way of drawing a line. And I want to be clear here, this is about trying to work within existing doctrine as opposed to what I might think is most normatively preferable. But I tend to think that the line is somewhere between policy and politics on the one hand versus administration on the other, and that when it comes to decisions that we might think of as political or policy decisions, we can have our cake and eat it too if we say that in those contexts, but those contexts alone, what we're interested in is presidential decision making, and that means control. And whether we get control through removal or through the ability to issue a directive, I'm sort of agnostic on. But the key point for me is that in other contexts where we're not talking about politics, but we're talking about administration, presidentialism requires merely supervisory authority, which takes us back to the first question about existing civil service law. All the way back to the Pendleton Act, it's clear that the president has a critical role to play in running the government, even as a supervisor, but there the president's job is to ensure good administration. Remember the Constitution, right? The president's duty is not to run the government, it's to take care that the laws be faithfully executed. And so to channel Gillian Metzger, that can create a constitutional duty to supervise in order to ensure good administration. So you were reminding us about INM, right? The standard protection for good cause removal, inefficiency, neglect of duty, and malfeasance in office. Don't quote me on this, but one way of cashing that out would be to say, if we're thinking about political questions, policy control, maybe INM shouldn't protect you from making the underlying political decision in a way that contradicts the president. On the other hand, if it's not a policy issue, well then INM really is just about good administration, in which case, even if the decision you're implementing is one the president disagrees with, it doesn't matter. Your job is just to do good administration, and the president's job there is merely to ensure good administration. Maybe the policy you're implementing was actually set by Congress and signed by the president in a statute, in which case, unless the president has an independent source of constitutional authority, you have to follow the policy of the statute. So that would be one way of cashing it out. For more, read my article on Arthrex.
I'm not selling you any law review articles. You guys can publish what you'd like. I wrote a short piece when Seal of Law was being litigated saying, you know, if the justices would just interpret inefficiency, neglect, and malfeasance as just authorizing a president to remove an officer for bad policy. And in Humphrey's Executor, it wasn't clear that there was a specific policy dispute even at issue. That'd be one way to lower the stakes and maybe render the statutes constitutional, but basically by giving the president the power to remove. For me, at the end, it's hard for me to see how the president can take care that the laws are faithfully executed in a meaningful way without, in the end, having the power to remove, and to remove quickly and to remove without explanation, an officer who he thinks is enforcing the laws in the wrong way or even enforcing them, executing them illegally. At the opening of our conversation, Noah pointed out, and it's true, that there is no removal clause in the Constitution. I think the best reading of that is that it was, at least at the convention in Philadelphia and in the ratification debates, it could be taken for granted that removal was part and parcel of the executive power. Appointments are provided for explicitly in the Constitution because there the Constitution actually was dividing the power a little bit between the president and the Senate for important reasons that Hamilton describes in Federalist 76. And so that would be different. It needed an explicit rule. Removal was implicitly, I think the Constitution is best read as including removal in the executive power and in the duty to take care that the laws are faithfully executed.
This ends our program. Thank you all for being here this evening, and please join me in thanking the wonderful debate that has gone on tonight. Thank you, Professor White. Thank you, Professor Rosenblum.